Good afternoon, friends, and thanks for joining this session. Uh, we will keep this little short, considering it's late in the evening here in India, and maybe late even late in Singapore and other parts of Asia where people have connected. And good morning and good afternoon to people who have joined from the western side, maybe London and other parts. So idea about today's session came about because uh, in our view, after the major amendments in our Arbitration and Conciliation Act in 2015 and 2019, I think this judgment, which we are going to talk about today, which is uh, related to the disputes between Amazon and Future Retail, in our view, uh, is having a very big significance in the jurisprudence, particularly on the emergency arbitration and how emergency arbitration will be dealt in India, in spite of the fact that the law did not recognize emergency arbitration, uh, which was in a way recommended under the 2015 Law Commission report. So, so there is a good amount of history around emergency arbitration in India. We had a couple of matters both in Bombay and Delhi High Court before related to emergency arbitration seated outside India, but this is the first case where the arbitration is seated in India, and the jurisprudence has been developed for the first time, and Supreme Court has said a lot about the enforcement of emergency awards passed by the emergency arbitration, uh, under the Arbitration and Conciliation Act. So that's one major piece that we wanted to cover through this judgment. The second, again, is since our new law on Companies Act 2013, which replaced the 1956 Companies Act and was implemented in parts over a period of time, brought in certain aspects which were first time introduced in Indian law, such as the fiduciary duties of the director, Section 166, the conflicts, the importance of actions or inactions on part of the nominee directors, independent directors, promoter directors. A lot changed in light of the Satyam saga and 2013 Companies Act. This judgment also dwells upon. So we are going to cover both the single judge Delhi High Court judgment and the Supreme Court judgment. And both judgments cover a lot about how corporate governance, directors meeting, the role and responsibility of a nominee director, promoter director, and their fiduciary duties vis-a-vis the company versus the obligations towards the nominator. I think there is a significant development in that area as well, where there was again not too much of jurisprudence interpreting 2013 Companies Act provisions, and thereafter how the board and the directors would behave. So with that background, we thought it might be a very good idea to have a discussion like this amongst a small group of people. We want to make this very interactive. So please feel free to put in your questions in the Q&A window or the chat window. Uh, uh, During the course, we will try and take it up, as and when those questions come up, rather than wait for the end of the session. So please feel free to put those questions in the Q&A window as we speak. To discuss these two broader topics, and of course, in addition to these two topics, which is one is the emergency arbitration, second is the fiduciary duties and how directors ought to act vis-a-vis the company and the nominators. The third aspect, obviously, which we will deal with, is the way the shareholder agreements are structured when there are, subsidiary parent kind of investments, and there may be, certain rights which the investor coming at the parent level may be interested so far as the subsidiary companies are concerned, and vice versa. So that is another angle in terms of the structuring of the shareholders agreements and the clauses related to control that we will deal with. Uh, with that background, let me first introduce our speakers today. We have two speakers from our dispute resolution and investigation team at Nishith Desai Associates. We have Ashish Kabra, who heads our litigation and disputes practice sitting out of our Singapore office. He's there for more than 2 years, and before that, he has spent considerable amount of time in our Mumbai and Delhi offices before he moved to Singapore. So welcome, Ashish, and considering it was a SIAC arbitration seated in India, I think there is a clear connection to Singapore built in as part of this discussion. And then we also have my colleague Mohammad Kamran, who is a senior member of our dispute resolution and corporate securities, litigation team. And he is based out of our Delhi office, and I am based out of our Mumbai office. So we pretty much cover a large part of different offices and the teams at NDA. So with that background, let me straight start the questions. And if I can come to Kamran first. So Kamran, let's first deal with the emergency award in particular, and the way the single judge and thereafter the Supreme Court dealt with the emergency award in the present dispute. Now, as everyone knows, this was a SIAC governed Singapore International Arbitration governed rules under the SIAC governed arbitration, but seated in India, and therefore there was an emergency award which was passed and contested for the purpose of enforcement in India. So, Kamran, if you can give us a background and how both the courts dealt with the emergency award.
Okay, so that was from a different computer actually, where I was using the PPT from. Thank you, Vyapak. Welcome everybody tuned in. So let me just start off by giving a brief background of what this. All right. So let me just first touch upon a brief facts of this case and how it led to arbitration situation. So basically, so Amazon had invested in future about 1,400 crores with the understanding that the promoter, which is the Kishore Biani Group and Future Group, will continue to retain the retail assets within the group, and with the understanding that if at all these retail assets are ever sold to any third person, they will be sold with the consent of Amazon, and with the understanding that they will never be sold to certain persons or certain restricted persons. Now, what happened was that Reliance was mentioned as one of the names in the restricted persons list. And in or around August of 2020, there was a board resolution which was passed by the future retail company, and we'll go into that in more detail how the structure was working. But for our purposes now, future retail passed a board resolution which had all the retail assets, basically approving the transfer of its retail assets to Reliance Group. Amazon, of course, was not happy about this board resolution. It had certain protective rights at different levels to ensure that this transaction never happened, and therefore invoking certain rights under their shareholders agreement at different levels, they started a SIAC arbitration. In the SIAC arbitration, the SIAC rules provided for emergency arbitration, and that is how the parties were before an emergency arbitrator. Now, before the emergency arbitrator, Amazon showed how it had these protective rights, uh, and how Future Retail could not sell these assets to Reliance, and how the rights were interlinked with each other and were working. And based on the submissions made by the parties, the emergency arbitrator ultimately decided on a prima facie basis that yes, there does seem to be a violation of the rights which Amazon had, and therefore it restrained Future Group and the promoter group to actually go forward with the transaction. It also restrained the Future Group from taking any actions, making any filings with the regulators to give effect to this transaction. And once they got the emergency award, uh, Future Group started treating the award as nullity, and they went ahead, started doing the filings. They continued with the process of moving forward with the transaction. Uh, of course, Amazon also did not sit back, and they also started writing to the regulators saying that they have in their hands this emergency arbitrator award, and any transaction which is contemplated by Future Retail of transfer of these retail assets to Reliance is in violation of their rights. And Future Retail, because of these kind of situation, this situation, Future actually filed a civil suit uh, against Amazon, restraining Amazon from tortiously interfering in its business. And of course, these proceedings question, of course, came up as to what is the status of this emergency award and whether it has any value to it. Uh, as a counterblast, Amazon also filed an enforcement proceeding enforcing the emergency arbitration before the Delhi High Court. Again, in the proceeding was this question of whether what is the Future Retailers make these arguments that or the Future Group made these arguments the award which is not contemplated under Arbitration Act. They also relied upon recommended amended to incorporate the emergency arbitration provision that not under law. Courts reject just one second. I believe mine is weak. Sorry about the video. So in both the courts hold that the emergency award was in fact 17 before the court, and the Supreme Court finally the arbitration award is something which is under 71 under the arbitration and procedure that the parties have conduct of those proceedings. The Supreme Court also held that there is nothing in the arbitration act which prohibited an award being an emergency, and in fact it went on to suggest that it will in fact decongest our court systems and will help parties to obtain relief in a timely and efficacious manner. So to sum it all, emergency award currently in this kind of a setup is in fact enforceable under Section 17, and that's where we are at, Vyapak.
Sure. No, thanks a lot, Kamran, and that gives a clear idea as to uh, you know how this award got recognized under Section 17 of the Arbitration and Conciliation Act of 1996 in India, which was amended in 2015 and 2019, which obviously came very handy for the interpretation as well. So with that background, and there is also a question from Sanjay Tiwari about would have uh, uh, made any difference had it been a Singapore City arbitration, and definitely it would have made a difference. That's the debate which is continuously going on at the moment. But we'll deal with that question as well. But let me go to Ashish first. in terms of the landscape for emergency awards and enforcement generally across different jurisdictions. And maybe you can also cover Sanjay's question as part of it, because that is important from cross-border arbitrations and particularly for India.
Sure. Thank you, Vyapak, and a very warm welcome to all the participants today who have joined in for this webinar. And thank you, Kamran, for that introduction that you gave earlier of the judgment and the explanation there as well. Now, emergency arbitration as a concept is not new, if we look at it. We ourselves did our first emergency arbitration back in 2012 under the SIAC rules. So now it's almost over a decade since this creature has been introduced or brought in into our laws. So what is happening today in India is something afresh in the Indian context, but emergency arbitration globally has been used and in play for a long period of time. Now, insofar as Indian parties are concerned, the unique feature about the Amazon case was the fact that this is the first time emergency arbitration in an Indian context or India-seated arbitration came up. But emergency arbitration has been there and has been used in foreign-seated arbitration by Indian parties. For example, in the Avitel, HSBC versus Avitel case, the Raffles Designs case, or the multiple cases of our Indian court as well, wherein the emergency arbitration which took place was seated in Singapore. And this is going to the question that Sanjay has raised, that what is the consequence if the emergency arbitration or the arbitration itself was seated in Singapore? The consequence which is there is that in such circumstances, you cannot take the emergency arbitration award and directly enforce it in India. But there is an indirect enforcement mechanism which has come through the various judgments of our courts in India, is that after obtaining that emergency arbitrator's order, we can apply to the court in India under the Indian Act for interim reliefs, in which case the Indian courts have, as a matter of practice, looked at these emergency arbitrator awards and passed orders in terms or basically reflecting those which were given in the emergency arbitrator's order. So that has been the process which has been followed in case of emergency arbitration seated outside India so far. In this case, it was the first instance of emergency arbitration seated in India. And therefore, the whole issue of whether this is quorum non judice, whether this concept is recognized under Indian law or not, arose. In other jurisdictions, for example, in Singapore, the law has been amended specifically, and in the Singapore International Arbitration Act, specifically within the definition of arbitral tribunal, recognizes the concept of emergency arbitrator, which was not the case in India because of the whole law commission recommendations, and which already my colleagues have discussed before, so I will not go into it. But that is the sort of difference which arises, was if the emergency arbitration was seated in Singapore, maybe things in fact would have been simpler in that circumstance, because those situations have previously arisen, whereas this was new. Now, even in Indian context, Vyapak, how I see this as a development going forward, because this is a new development, but what will be the impact? Because emergency arbitration as a principle or as a matter is only coming through institutional rules. So do we now expect that, given this development, parties to now further adopt and choose institutional arbitration more often? Because we don't have any rules, or the Arbitration Act itself does not provide for emergency arbitration. So it is only when a party chooses institutional rules would this creature come into play. The another interesting issue which I see arising is, and this is particularly due to the reasoning of the court, is that once you adopt an institutional rules, and emergency arbitration are part of that institutional rule, such as MCIA, the Mumbai Center for International Arbitration. Once you adopt those rules and the emergency arbitration is part of it, and when a dispute arises, can then the party have the ability to still go to Section 9 under the Indian Arbitration and Conciliation Act, that is, approach the court directly for interim reliefs? Looking at the reasoning of the judgment or the reasoning provided in this case, one could easily say that going forward, if one chooses emergency arbitration, the parties may be required by the court to first go and try or take this remedy of emergency arbitration before approaching the court, or rather than approaching the court under Section 9. Now, this was something similar which also sort of emerged from this judgment of Gerald Timis in England, where in this case, the court indicated that the parties could have approached the emergency arbitrator rather than coming to the English court for interim relief. And the interesting piece was over there, we see that agreements which emerged thereafter, parties started excluding emergency arbitration while entering into the arbitration agreements. So it will be interesting to see now with this judgment how Indian arbitration agreements evolve in the future. Are we going to see more adoption of institutional rules on a more regular basis? And second, if they do adopt, would parties be excluding emergency arbitration at that stage itself? But yeah, this is sort of a landscape which we are seeing in Singapore. We have the law, the difference I've already discussed.
Sure. No, I think this is very interesting, particularly some of the observations of both the courts, that in spite of the fact that the Law Commission in 2015 recommended to include emergency arbitrator as part of the process, the Parliament rejected the recommendation, and the courts have interpreted that rejection as in a way that doesn't mean that they wanted to exclude or it is illegal to have an emergency arbitration so long as institutions provide for those rules and parties have chose to adopt those institution rules as part of their party autonomy. So they are basically saying, look, it was your choice to adopt the rules. Now, if they are there is nothing illegal about it, in spite of the fact that Parliament rejected the recommendation to include emergency arbitration in India. So it's a very, very interesting development, and the way the courts have interpreted the recommendation from the Law Commission versus what got passed through in the Parliament, as part of the amendments. Going little forward, and this, of course, there are nuances to the emergency arbitration, and this topic in itself can take a very long, time to discuss. But the other aspect which gets missed out in the focus of this whole emergency arbitration is to even understand what was the dispute to start with, right? Why Amazon and Future, who were partners or who continue to remain partners in that sense, as part of their retail business, got into a dispute, and in a deal which was possibly one of the biggest deals of those of last year, which was almost 25,000 crores, and which Future Retail got into because of they were in need of funds. So, Kamran, if you can give us a little background to the dispute itself, to understand why we got into this situation in the first place.
Sure. So I hope the PPT is up on the screen now. I'd just like to use the structure so that it's easier to follow. It's a slightly complicated structure without the PPT, I would say. So what happened is that there were these two crucial entities, FCPL and FRL, both Future group entities. Now, this FCPL entity was held by another Future group entity, FCRPL, and members of the Biani family. And Amazon had actually invested in FCPL for 49% equity stake. So Amazon had 49% equity stake in FCPL, which in turn invested the entire monies which was invested by Amazon into FCPL. FCPL invested it in FRL. Now, FRL is the listed entity. FRL is the entity which we are talking about right now. This is the entity which had all the retail assets. This is the entity which was planning to divest or hive off all these retail assets to Reliance. And this is the entity from where the problem emerged. So the way the rights were structured, basically when Amazon invested in FCPL, Amazon had a shareholders agreement with FCPL and the other promoter, which is FCRPL and the Biani family. And when FCPL in turn invested that money into FRL, FCPL had a shareholders agreement between FRL and the Biani family being the common shareholder at both levels. So now we have two shareholders agreement, one at the top level, one at the bottom level. Amazon is party to only at the top level where it has invested directly. FRL, there is another shareholders agreement at FRL level where Amazon is not a party. But the way the rights were structured were that there were some reserve matter rights in the FRL SHA, which could not be undertaken without the approval of FCPL. And FCPL could not have approved those reserve matter items without the approval of Amazon. And that is how the rights were structured. So, and of course, when we go into more detail of as to what happened, we see that the parties have also argued that because of this, Amazon has indirectly exercised a full-scale control over FRL, and there are multiple other arguments that were taken in different proceedings. But this is basically how it was structured. Now, what really happened was there was a board resolution, there was a corporate action which was passed at FRL level. FRL passed the board resolution hiving off the assets to Reliance. This, of course, Amazon came to know about this, and that's how, how I stated before, that's how the emergency arbitration started, and the award came through. And once the award came through, like I said, Amazon also wrote to regulators about this board resolution not being in violation of its rights under the SHA and not being in line with the FCPL articles of the association and all. So there were three main proceedings. Actually, I would say there were two main proceedings. One was the proceeding by Future Group against Amazon to restrain Amazon from tortiously interfering by writing to these regulators. And second was the proceedings which was filed by Amazon to enforce the emergency arbitrator. Now, in the proceedings of Future Group, where they were seeking to restrain Amazon from tortiously interfering, an interesting question arose as to whether the board resolution which was passed by the board of FRL, whether that was valid or not. And another question which arose was whether the rights which Amazon had in this entire arrangement, whether that amount to excessive or full-scale control over FRL, and whether that is permissible under foreign exchange laws. So that is how the dispute came about.
Yeah, no, thanks, Kamran, and that takes us nicely into the next question that I wanted to touch upon, or the topic that I wanted to touch upon was on the exchange controls. Now, as a lot of people on this call would know, we have still certain restrictions on exchange control, how much you can own, how much you cannot own for certain sectors, particularly the retail, which is the matter in question. And obviously, there was a structure where Amazon invested in FCPL, which further held 9.8% in the FRL entity. But there was a nuanced argument on this as well, as to whether this structure is kosher, whether this can be the obligations under this structure can be implemented, vis-a-vis the applicability of FEMA and the exchange control restrictions, or this is not allowed in the first place and therefore cannot be exercised. The contractual obligations cannot be, implemented. So, Ashish, if you can give us a little idea about that, as to what was the, argument on both sides. Of course, single judge has given some prima facie conclusion, which is still subject to fuller, adjudication. But maybe at this stage, it would be important to understand this nuanced argument when people are structuring and entering into different kinds of shareholders agreements. You are on mute.
Apologies. I think the interesting piece over here and why these issues were arising or being put were for various reasons, and we need to understand those to understand why this issue came up in the first place. And as my colleague Kamran explained, Amazon invested in FCPL and was not an direct investor in FRL. The reason there for that was that any direct investment in FRL, which is in the sector of multi-brand retail, would require prior government approval. So what Amazon, so the structure which was adopted in this case was that Amazon will invest in FCPL, which Amazon says is in the business of carrying out cash and carry wholesale trading, which is a automatic route permitted sector in which it could have invested up to the amount it did. And further, it only invested or held 49% of FCPL. Consequently, FCPL was not controlled by Amazon. And further, the FCPL's down investment would therefore not qualify as a foreign investment into the retail sector either. And therefore, there is no foreign exchange violation. On the other hand, Future, which is the Biani group, they were asserting or trying to claim that, look, and this is connected to Amazon's case, because remember, Amazon has only invested in FCPL, and it is a party only to the FCPL shareholders agreement and not a party to the Future Retail's shareholder agreement. And here, the resolutions and the actions were being taken by Future Retail to sell its assets, where only FCPL's consent was required. So Amazon effectively was conflating or combining the two agreements and saying this is one transaction. And consequently, in arbitration, because Amazon started an arbitration where it is taking reliefs against Future Retail, where it has no direct agreement with Future Retail in that sense, because the agreements are split. So it was saying that this is all a part of one composite transaction, and consequently, under Indian laws, it could include Future Retail as a party to the arbitration. Future, on the other hand, was saying that if you conflate all of this into one, and if you see what Amazon is actually doing, would actually show that Amazon is controlling Future Retail, which is something not permissible under the exchange control laws. The exchange control laws does not allow Amazon to directly invest in and take rights in Future Retail, as it is a foreign entity, and this comes through the government route. So Future was therefore contending that by doing what Amazon is doing and by seeking reliefs that it is doing in the manner it is doing, it is actually violating the exchange control laws. And this is the whole background and why this issue arose in this scenario. Now, this is not the first time, and this is a trend that we see emerging through various cases in India. When parties are actually entering into the deal, and because at the deal making stage, everybody is happy and they're trying to work with each other, everybody is coming up with solutions to work around the exchange control restrictions in India, which can at various places be either ambiguous, or the approvals thereunder could take a significant period of time, and therefore sort of defeating the commercial intent of the parties at that particular time, which they have, where they are willing to work together. Consequently, at the deal making stage, parties are working together and find solutions or workarounds to basically ensure that a deal is done and the exchange control restrictions do not come in the way. However, when things go south, and this is not the first case, we saw this in Tata versus Docomo, we saw this in Cruise City, there's a recent judgment of Supreme Court in the Prismian case. At various places, parties have taken, or whenever things went south in disputes which have arisen, arguments based that the agreement is in violation of the exchange control laws have been raised. Now, I'll just be sort of mindful over here and would want to highlight that the Indian courts have actually to our knowledge, in almost all cases, come to the aid of the foreign investor, where somebody has willingly invested or willingly entered into certain agreements. Various reasons have been brought up to say that the agreements in violation of foreign exchange laws, or agreements, even though there may be some contravention of exchange control laws, would not be invalid. And therefore, the trend is, even if these defenses have been raised, those have not been upheld. Now, I know that's not part of our focus over for today, but this is something that I wanted to highlight. Even in the Amazon versus Future scenario, we are only at the interim stage. So this is something that may still go on before the tribunal in Singapore, and we'll have to wait and see what's the outcome there. But this is the trend that we are seeing come up, and how Indian courts have mostly rejected any arguments which have come around this, at least in the context of enforcement of foreign awards.
Sure. And thanks, Ashish. And I'll come back to you maybe a little later on certain exit rights and how the do's and don'ts in terms of the shareholders agreement little separately. But the point that you took here dovetails into another topic of control, which is again a very I would say contentious matter, and several different laws, say it in a different way and interprets it in different manner when it comes to, Indian structuring for investments from foreign investors. So let me first bring in Kamran on that point, because the way the structure was 4951 and then holding less than 10% in FRL. There was also an argument on control and whether that could amount to any consequence so far as the way both the shareholders were exercising their rights so far as the governance of FCPL and consequent FRL is concerned. So Kamran, if you can touch upon that part a little bit and explain what was the argument and how it affected the dispute, and how particularly the single judge of the Honorable Delhi High Court has dealt with that issue.
Right. Thanks, Vyapak. As you rightly pointed out, control is a very extensive issue. It involves multiple laws. Multiple regulators have tried to interpret it in different ways. It has been interpreted by Supreme Court as well. And we have seen an evolution of the definition of control. So from the time when it was just the power to appoint majority directors on the board of a company, it has evolved much further to, it now includes having the power to influence the day-to-day management of the company, having the power to influence the policy decisions of the company. And all of this will now amount to control. And recently, the Supreme Court, in fact, not very recently, but yeah, the Supreme Court has, in ArcelorMittal case, there was this issue which came forth as to whether the veto rights would amount to control. And Supreme Court said that in order to protect the investment, the investors like to, build in some protective rights. And these protective rights are only which directly impacts the investment, and they don't really amount to control as such of the company. Now, what has happened at the Delhi High Court single judge bench level is that the court has actually taken the principle from ArcelorMittal, and they have tried to analyze the facts of this case to actually see whether the rights which were available to Amazon were only to protect their investment or something even more. And there the court has said that, look, let's just see what FRL was allowed to do. And when you look at FRL's SHA, there were certain permitted transactions and there were certain restrictions which are encouched into reserve matter rights. And what they found was that the FRL could not have done majority of the work without the consent of FCPL, which could not have consented without the consent of Amazon. And what was permitted by these agreements for FRL was very limited rights as regards the non-core assets. So they say that these non-core assets, FRL could do whatever it wanted to only with respect to non-core assets, which were just 2% of the total assets that FRL had. And therefore, practically, it could not have done anything with its assets unless and until it had the permission of Amazon all the way up. So, and there the court says that, look, this is Amazon has only 49% in FCPL, which in turn has only 9%, 9.8% in FRL. Practically, that puts Amazon at 5% at FRL level. But the rights which Amazon has at FRL level is so disproportionate now. It is quite disproportionate to the shareholding it has, which is only about 5%. And I'd like to just show some excerpts from the court on this aspect of control, and that will make things much clearer. The court here says that imposition imposition of restrictions on voting rights for all promoters and shareholders without the prior consent of the investor, and rights to interfere beyond the protective rights of the investment and disproportionate therefore may cross over from protective rights to controlling rights. And then the court further holds that cumulatively it is clear that Amazon's consent is required by FRL to act upon reserve matter, and without the consent of Amazon, FRL is only entitled to deal with the permitted transactions. Now, given the narrow ambit of the permitted matters that can be taken up by FRL without requiring the consent of Amazon, there is a prima facie, a very limited discretion available for FRL for conducting its own business. And this, they say, that on conflation of the two shareholders' agreement, prima facie it appears that the rights are disproportionate to the actual shareholding of the Amazon, and by conflating the of words by the extensive rights held by Amazon uh, by provisions of the agreements cannot be masked as mere protective rights so as to fall beyond the test of control as laid down in Arcelor versus Mittal. And of course, these are now prima facie views. We'll have to wait to see what the final judgment emerges on. But this is the view that was taken by the single bench.
Thanks, Kamran. And this is a very interesting development because, again, from a legal community and people doing business in India, this aspect of control has been a constant debate because balancing between having protective rights versus taking control has always been a bone of contention, and deals with a lot of structuring issues. So everyone will be waiting for further guidance on this as the matter progresses. I want to then address and touch upon another critical piece which has come out of this jurisprudence, which is the behavior or the action or inaction on the part of the directors, whether they are promoter directors, whether they are nominee directors of the lenders, creditors, whether they are independent directors, whether they are a nominee of significant shareholders. I think there is a lot of confusion, or I may say lack of clarity on each of the role, responsibility, and obligation of such directors for their fiduciary duties for the companies vis-a-vis their obligations to the nominator. And that, again, in my view, this jurisprudence, as it progresses, will give very good understanding as to how you structure some of those aspects while investing in India. So, Kamran, if I can still continue with you, and here the issue was future retail was obviously facing a lot of financial trouble, as they call it, as a doomsday scenario, and there were certain contractual obligations on behalf of the directors, the promoter directors, and the nominators versus possibly what was required by the company at that point in time. If you can give a very quick overview on the issue, and then I'll go to Ashish for a larger understanding on the do's and don'ts on the nominee directors.
Right. So I think one of the points of contention in the civil suit was that the board resolution which was passed at the FRL level was void and invalid. And the court said, okay, let's just test the validity of the board resolution. Does it violate the Articles of Association of FRL? Is it violative of the Companies Act? And on all those counts, they found that there was no violation, except that there could have been a violation under the contractual agreements or arrangements between the parties. So on that aspect, the court says that look, ultimately, the board has a fiduciary duty towards the company, and first, and then towards the members as a whole, and then towards the employees, community, even the environment is now included in the 166. And what it found was that, look, while there can be violations of contractual agreements, which again has a separate remedy under different laws. For example, if there's a contractual violation, you have a remedy under Contracts Act. But so far as the board resolution itself was concerned, they only had to test it as to whether it was in line with the articles of FRL. The articles of FRL only provided that this is an item which has to be passed with the consent of FCPL, and interestingly, FCPL actually filed a letter saying, which letter was signed by both parties, FCPL and FRL, approving the FRL transaction with Reliance. Now, of course, parties challenged the validity of this letter also, and they questioned this as well, which will again be dealt with in detail when the final judgment as the final judgment comes out. But on a prima facie view, the court looked at this letter, which was from FCPL, which approved this transaction for FRL. And therefore, they said that there was nothing which was violative of the FRL Articles of Association, which means that the Board of Resolution prima facie was valid in nature. So that's how they decided the question of board resolution.
Sure. And this, as we were discussing this, raises a very interesting question as to what a nominee, director can do and not do. While at one end, in a way, they have to ensure that they, put their interest or the shareholders' interest in front of everyone. But as a director, they have a statutory obligation for making sure that fiduciary obligations are not violated. And now with Section 166 in the Companies Act is all the more important as to how these directors would have to act in future, in future, not talking about the company itself. So I think, Ashish, if you can give a little bit of an context as to how this law has evolved over a period of time, how different statutory laws and Companies Act particularly and other acts deal with this aspect of director obligations, and with this jurisprudence, how it changes or at least gives some clarity.
Sure. Thank you, Vyapak. I think the first thing I want to actually highlight is that when we are speaking of the single judge, we should note that this is not a judgment overturned by the Supreme Court. This is a separate proceeding where the single judge's order still holds good while it is under appeal. But these are separate points in the civil suit which was initiated, whereas what was before the Supreme Court was the emergency arbitrators orders enforcement proceedings. So that's separate, and to that extent, the single judge's order, which Kamran alluded to or explained earlier, still stands good. Now, the point regarding nominee directors and the takeaway from the judgment and where the law is currently in India, I think, as my colleagues explained, the nominee directors, rather in this case, the situation was that the individuals who were party to the shareholders' agreements, under the agreements, had taken on the obligation to vote and ensure that the obligations in those agreements would be complied with. Now, under SHA or under a shareholders' agreement, we typically have rights where investors or the promoters would have right to nominate these individuals. And very often we would also see that an obligation is cast on promoters, as was the case in Future Retail, to vote to ensure that the provisions of the agreement are given effect. Now, this judgment actually makes it important for parties to be mindful of the fact that an agreement with a director or an individual in his capacity as a director is not the same as an agreement with an individual in his capacity as a shareholder. When one exercises his shareholder voting rights, these are proprietary rights attached and not fiduciary rights in that sense. And shareholders by agreement can agree to exercise these rights in a certain manner or through an agreement regulate it or agree how they would do it. Whereas fiduciary obligations come from law. And this is where as Vyapak was asking me earlier about what's been the history. And the history generally has, from where we stood, at least in an Indian context, few years back where these rights were not codified, something drawn out of from the common law. That has changed with the enactment of Companies Act, and now these are codified under Section 166 of our Companies Act, and which cast clear obligations on director or how they need to be when exercising their obligation or when performing their duties as a director. So, in context of shareholders agreement, if you impose any obligation on an individual in his capacity as a director to vote in a certain manner, that would not work because the Companies Act clearly obligates him to perform that function and perform his duties in a certain manner. So that is something that parties should be mindful of and cautious of, at least when negotiating or when agreeing on shareholder agreements. The other piece is in terms of generally how are directors required to be under law? The answer to that is that there's the consistent position, at least through case laws in India, has been that the director's primary fiduciary duty is towards the company and not towards the nominating shareholder. Now, we do note that there is jurisprudence, particularly from jurisdictions such as Delaware and other, let me say, developed jurisdictions where the jurisprudence and also the principles or the way the companies operate is fairly developed and professional as compared to other parts. There we do see a balancing exercise being done, where to a certain degree, the directors are allowed to vote in favor of their nominating shareholders or to take those into account while exercising their duties. Even in India, if you see the recent other judgment, which is the Tata versus Mistry debate, even there, the Supreme Court has alluded that in certain situations, interest of nominating shareholders can be taken into account, though the principle so far remains that, look, the primary duty is owed towards the company and not towards the nominating shareholders. But as I say, as the market brings more sophistication is brought into the market, the board becomes more professional, we will see that there is certain degree of differences which arise. For example, the whole objective of getting independent directors on board is to provide that independence and in that decision making and thought process. So when you have independent directors on board, the others, there has to be a certain degree of differentiation between a duty of an independent director and a duty of a nominated director. But those are nuances which is still in development phase in an Indian context. This judgment does give few takeaways, at least in context of shareholders agreement, which is that be mindful when agreeing to rights with an individual, which he will exercise in his capacity as a shareholder and when he will exercise in his capacity as a director.
Yeah, no, thanks, Ashish, for that clarification. And we are coming very close to 6 p.m. and the end of session. And we have possibly covered all the 3 points, very well in that regard. But if I may come both of you for your final takeaways on this aspect and what to expect in future, so far as this matter is concerned. Maybe 1 minute each, and we'll close the session.
Sure. So maybe I start, Amra?
Yeah, sure. Please go ahead.
Sure. Thank you. So I think the dispute in this case, or the reasons at least given in the judgment, is somewhere that the issue arose due to the whole pandemic coming in and hitting the retail sector really badly, causing a liquidity crisis wherein a person has emerged who is ready to or was putting in money in the business or buying the business. And now that deal was essentially to pay off the lenders who have been asking for money. Now, if this effectively what the Supreme Court does is enforce the emergency arbitrator's order, and consequently what is happening is the deal is being stalled. So from that perspective, what I see is the lenders getting stuck or not getting paid. And if that is the case, I think we will see that the next battlefront is the National Company Law Tribunal and the Insolvency and Bankruptcy Code, which may come into picture and the future. But obviously, this is just a sort of crystal ball gazing which is being done. Obviously, the matter could take various other routes as well. For example, the arbitration is ongoing. We know that there have been, at least from the newspaper reports, that the hearing before the tribunal on the interim orders is completed. So I think parties should now look forward to that, at least in the near future, as to that would give of where this matter is next headed. But this is just a sort of crystal ball gazing that I can do, Vyapak, at my end.
Yeah, sure. No, thanks. Kamran, your last words.
So thanks. I think Ashish covered most of it, and that's how this is. We have many different ways in which the matter can unfold. What I wanted to just briefly cover here is that we get a lot of queries on, on the last point that Ashish covered, which was the duties of a director and the duty that it owes towards the nominator. And let me just very quickly show an excerpt from the court on this point, where the court has quoted an English UK judgment, and it says a director may owe duties to his nominator if he was an employee or officer of the nominator, or by reason of a formal informal agreement with his nominator. Such duties did not arise out of his nomination, but out of separate agreement or office. Such duties could not, however, detract him from his duties to the company of which he was a director when he was acting as such. An appointed director, without being in breach of his duties to the company, may take the interest of his nominator into account, provided that his decisions as a director were in what he genuinely considered to be the best interest of the company. So that's with that, I'd like to just close the.
No, this is the most important point in my view, where we really need more clarity, considering the way the economy and the businesses are growing in India. So with that note, and with a promise that we'll come back soon, the way the matter is progressing. Thank you everyone for joining and staying on. Thanks Ashish and Kamran for giving your thoughts. Thank you.
Thank you very much.
Thank you, Vyapak, for moderating the session. Thank you so much.